Welcome to the Ninth Amendment Party, the South Carolina chapter. All information is verifiable at United States Code, Code of Federal Regulations, Bouvier's dictionaries, Black Law dictionaries, the Uniform Commercial Codes, and congressional records. The questions many have on their minds today are just what is the condition of the Republic? Is the posterity of we the people destroyed? Can the Republic, as it once stood, be reformed? Nationally today, the Republic was under a socialistic power enforced by a military venue and a martial law jurisdiction under the authority of the President of the United States Incorporated and regulated by the Socialist Congress. The legislators of the several states have either been forced through blackmail or have willingly cooperated in reforming the United States of America by converting the Christian Republic form of government of our nation into a socialistic democratic republic under national military rule, i.e., martial rule. This trend to reform America into a socialistic democratic republic began in earnest with the 39th Congress. The 39th Congress of the United States convened in the Capitol at Washington on the 4th day of December, 1865. The Civil War has been considered ended, even though the Southern states were still under military authority, parentheses, martial law, and the Southern states were not allowed to be represented in the House or Senate at the time of the 39th Congress. Only congressmen and senators from the northern states were represented in the 39th Congress, which means the conditions of the republic we live in and by today are a direct result from a Congress that did not have representation by congressmen or senators from 11 of the several states. And thus, it was a Congress that conveyed with a full power of martial law to enforce all of its legislation of the socialistic democratic republic. Today, we're going to be looking at legal word and the crafting of this legal word. We depend on words. We place enormous faith in words, that they mean and sound as intended. In order to live in this world, we trust words using words like trust from the 12th century Latin, truste, in equals an approved agreement, a deed, oath, or alliance as a subject of the church, in reference to the Roman Catholic Church. Its claimed origins from Old Norse deliberately misleading. Is this what you mean when you use, write, and speak the word trust? Have you consented to an oath or alliance as a subject of the Roman Church enthroned at Vatican Hill? Maybe you have, maybe you have not. But most people would never have heard of this original and primary meaning, the true intended meaning of the constructed word. Why is this first meaning of the word important anyway? Well, we are taught that words are pegs upon which ideas are attached, mere tools to convey meaning, not really having any great and mystical power. Yet this deliberate, confused teaching is in the direct contradiction to the very nature of words and their vocal pronunciation throughout history. Words are power. Special words have special power. The ancient belief in words having magical power. So thought the Egyptians, the Sumerians, the Phoenicians, the Greeks, the Romans, and all ancient civilizations that created new forms of writing, attached meaning to the arrangement of symbols, including meaningful sound. From the very beginning of civilization itself, words themselves were magical. And to know the true meaning of a word and its origin was to hold in your grasp real power. The origins of words and power. It is one thing to forget the precedents of history that the true meaning of a word is power. It is another thing entirely to forget that all language created by men and women, has a single point of origin, an architect. As it happens, there are specific points and individuals in history that excelled in the creation of new words and meanings, with the long periods of use over eventually declined. Why are the true original meanings of so many words hidden? So, how come the original meaning of trust is hidden? How come originally meaning of so many words were taken for granted? For example, understanding meaning. To stand under the authority of the Catholic Church, the Roman Catholic Church, are also deliberately hidden. Let's rephrase that. For example, understand meaning. Okay, to stand under the authority of the Catholic Church. This is still used today in court systems around our country. Do you understand your charges? Do you understand contempt? These are things that throughout history all reflect back to the true word under the authority of the Roman Catholic Church. The answer is simple. They do not want you to know the true nature and the meaning of these words you use every day without ever questioning what you are actually saying under their system commercially, from person, corporation, to claim, to resist, to deposit, to receive, to even the word law itself. The catch 22 of modern law and meaning of keywords, a classic of why the system of deliberately hiding meaning is in place is in regards to the practical operation of local, national, and international law. Many a bright person who has studied law soon identified key words that have important power within the legal system. Regina, meaning the crown, is one such example. But unless an individual can demonstrate to the court an understanding, standing under, remember, and precedence of legal terms being used, the knowledge of key legal terms and ancient legal phrases are of little use. But when an individual is capable of demonstrating a real understanding of words within a court, then it is possible to shift the power almost immediately to your favor to some degree. Mark Twain once said, "The difference between the right word and the almost right word is the difference between lightning and a lightning bug." My mentor and law instructor on being a sovereign national, Gary DeMott, was inspired by those previous slide, who liked to say the difference in describing a lightning bug and a lightning bolt is only a couple of letters, but you had better know the difference before you go out and try to catch one. Words have so much meaning. Could you catch a bug without being hurt? Could you catch a lightning bolt without being hurt? Words have meaning. In law, words have exact meanings, and the use of law revolves around how words are defined. Imagine if one letter was changed in a legal document with the intent to trick you. It is done all the time. One letter in law can be just as important as the difference between an M16 rifle and an F-16 fighter plane. And it can be just as damaging to an innocent victim. We seldom try to understand the meaning of words. We just seem to mouth them and hold them dearly, but seldom attempt to investigate their substantive implications and precise meanings. How easily we are put to sleep by our eyes, even when we are awake. Robert W. Wainwright. It doesn't take long with the law dictionary to realize that there is more than one reason people love to hate attorneys. These drafters of encoded laws are artists when it comes to using words to deceive us. The concept introduced in this presentation is a recurring theme throughout this video, and it ties into various subjects. Some of my favorite examples of this art need to be held back until later in this presentation because of their ties into subjects I haven't explained yet, and some are important enough to require their own video, where I have room to present supportive evidence. In spite of these challenges, I want to introduce legal word crafting early so you would be thinking about it. I have spoken to strangers for only a few minutes using 2 or 3 examples and witnessed more lights coming on in their eyes than if I spoke on any other subject. Nobody likes to be played for a fool. A good example for you to consider is the word inalienable, or what I like to say, unalienable. This important word is found in the Declaration of Independence in reference to certain of our most important rights, such as a right to defend ourselves. These rights are incapable of being sold or transferred. They are unalienable, unalienable, not of commerce. It is no surprise that those who want to rule over us had to come up with a substitute for that. They did, of course. The word promoted today is inalienable. In. By changing one letter and making it sound quite different rather than alien, they figured we could be kept in the dark as to the word's true meaning. Black's Fourth informs us that certain inalienable rights may be sold or transferred under certain circumstances. I wonder if they might have had themselves in mind to decide of what those certain circumstances might be. Whenever they choose to violate our rights, perhaps they knew exactly what they were doing. Upper and lowercase letters are used often in legal writing to flag hidden meanings, like a secret code. It is amazing how using uppercase in place of lowercase letters can change a word's meaning in legalese. These artists of deception include alternative meanings in their law dictionaries, so they can deny accountability and look down their noses at you as if you have mental problems, all while knowing that they are the ones who set up the deception in the first place. They are quite proud of themselves for their supposed superiority in understanding these legal tricks. Consider the following question many have faced with on a typical job application. It is a good example how words are used to deceive us. There are 3 traps contained in this question, all designed to obtain or presume jurisdiction over you. Are you a lowercase c citizen of the United States? Have you ever seen this on a job application? Have you ever been asked this on a driver's license application? Have you ever been asked this in reference to purchasing a home? The question, are you a lowercase citizen of the United States? The first word I would like to draw your attention to is citizen, the first trick. Prior to the 14th Amendment, where this word with a lowercase c was first introduced, the founders always spelled it with an uppercase C. This was done to imply sovereignty, as free white citizens were specifically recognized as sovereign in this country's early years. A citizen is sovereign and not subject to anyone without his or her consent. A lowercase citizen is subject as a slave. Again, uppercase citizen, Big C, small itizens, is the sovereignty of the introduction by our founding fathers. The lowercase citizen is the subject slave invented on the 14th Amendment. Also part of the District of Columbia, which was in the process of being revealed. The founders had debated this issue. Some were concerned, not wanting to offend God, our true sovereign. They hesitated to refer to the people as sovereigns, believing that they were subject to God. Sovereign, Black Law Dictionary number 5. A person, comma, body, or state in which independent and supreme authority is vested. Now remember, person is defined as a corporation. Body is defined as a quasi in rem corporation or agency of the state. Sovereignty, the supreme, absolute, and uncontrollable power by which any independent state is governed. Supreme political authority, the person or body of persons in the state to whom there is politically no superior. Again, remember that sovereign and sovereignty, the original term, has been defined to protect the government within the commercial status that they are operating in. Sovereignty is basically not being subject to another of higher authority. And our country's founders had enough of wicked kings and such. Some argue that if they referred to the people as anything other or less than sovereign, someone would eventually come along and presume the right to step into a position of control over them. Their concern was more over the probable designs of wicked men than the possibility of a mild offense toward God, whom they believed would understand their dilemma. They were focused on protecting the people from wicked men and didn't want to leave such an obvious opening for someone to take advantage of. So this side won the debate. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to agencies of government, sovereignty itself remains with the people by whom and for whom all government exists and acts. And the law is the definition and limitation of power. Justice Matthews in Yekwu versus Hopkins, 118 U.S. 356. I will provide more details later on, but the 14th Amendment was pushed into a place to provide a status for the newly freed blacks. It created a different class of lowercase citizens, lowercase c, that were as creations of the District of Columbia, the corporation subject to it. These subject citizens had only privileges that the corporate state allowed them. In the 14th Amendment, these are called civil rights. Civil rights are nothing more than government-granted privileges. If you state that you are a lowercase c citizen status, you will be considered a person without any rights. Definition of a person, again, is a corporation. The second trick that they like to utilize. Next, consider the words United States. This is not in reference to the United States or States United that the founding fathers were referring to. With the first letters capitalized or all letters capitalized, the words United States in upper and lower case, as well as the word United States in all capital letters, identify as a privately owned corporation. The Corporation of the District of Columbia was formed on February 21st, 1871, and it was reorganized on June 11th, 1878, and renamed the United States Government in parentheses. This corporation privately trademarked as well the names United States, US with the dots after the U and the S, the US without dots, the USA with dots, and the USA without dots, and also America. Prior to this deceitful act, the words of the term United States meant simply the states united for a common purpose. The United States Inc., established 1871, is like the Ford Motor Company, Detroit, or the Baskin-Robbins Company of Chicago. It's simply a corporation based in America. If you look up the definition United States in Title 28 U.S.C. 3002, subsection 15, you will find that it means a federal corporation or some entity, and remember, an entity is an agency, quasi in rem, of the federal government or instrumentality of such. The location of the United States is delineated in the UCC Uniform Commercial Code under Section 9-307, subsection H. The United States, upper lowercase, the United States in full case, is located in the District of Columbia. The Uniform Commercial also states that the United States includes its territories and possessions and Commonwealth of Puerto Rico, UCC Section 6-102, subsection N. Why Puerto Rico? Well, through the credit debit system of the fiat currency, through the Federal Reserve, that treasury is located in Puerto Rico. Now, the third trick. The third trick is used of the word of. If you state that you are of something, you are acknowledging that you are a subject to it and that it is superior to you. If you said you were of instead of for the United States, you are saying in legalese that you are subject to the United States corporation and inferior to it. That simply puts you under their subjection and also jurisdiction. Of, a term denoting that from which anything proceeds, indicating origin, source, descent, and the like, as he is of noble blood. Now remember, we are not supposed to have any titles of nobility as representatives of the people. Associated with or connected with, usually in some casual relation, efficient, material, formal, or final, the word has been held equivalent to after, at, or belonging to, in possession of, manufactured by, residing at, from. And that's Black Law Dictionary 6. If I said, I am a son of God, I would be saying that I am subject to him, since I believe I was created by God, and he is greater than I. It would be correct to say that I am of God, or a son of God, or a daughter of God. Are you a lowercase citizen of the United States? Do you want to be? I am an American national / uppercase C citizen. By this statement, I maintain claim of my sovereignty under God, and no other man in this world has a superior claim. Color of law. If you find the above mildly disturbing, you should investigate property titles. If you understand the importance of property, you're likely to realize that gaining control of all of your property is the same as gaining control of your lives. There are over 70 forms of deeds, all under color of law, which means the appearance or semblance without substance of legal right. Misuse of power. Think of all the political individuals today that abuse their power, made possible only because the wrongdoer is clothed with the authority of the state. Who is the wrongdoer? That is any elected official, employee of government. Let it be within the executive branch of the state. Let it be in the legislative branch of the state or the judicial branch of the state or an employee of all those three. Black Law Dictionary, Volume 5. In legalese, color means an appearance, semblance, simulacrum, as distinguished from which is real. A deceptive appearance, a plausible, assumed exterior, concealing a lack of reality, a disguise or pretext. Black Law Dictionary 5. Think of what we're saying, color of law. Looks like law, smells like law, voted in as law, but it all violates the constitutional principles of unalienable rights that God has given to each of you, nature's rights. I thought it interesting that this would be admitted in a law dictionary. The peculiarity of the mirror. What is seen to be right is left, and what is left is right. Master Ken, episode 24 of Kung Fu. Lawful is not the same as legal. Something being legal or illegal does not mean that the same thing is lawful or unlawful. Legal only means it was legislated. Remember what I'm saying here, okay? Color of law, legislated. It may or may not be law. The meaning of the word legal is color of law. Legal tender, for instance, is not lawful money. In other words, fiat currency that we use today from the Federal Reserve has no backing. It's a make-believe credit debit system. There's a huge difference with no backing of financial currency to what our country was designed. We have, which is specific weight and purity of silver, as well as gold within the original aspects of the United States for America. Who is the client? Previously, I said we would take a closer look at the word client. Attorneys have. Attorneys have an obligation to the courts and to the public, not to the client. And whenever the duties of his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. In other words, the attorneys, when it comes right down to the bar, the British accredited registry system, okay, their duty is to the court. This is verified through Corpus Juris Sectum, 1980, Section 4, Redemption in Law, 2nd edition, page 89, and hereafter referred to as RIL, 2nd edition. Clients are called wards of the court in regards to their relationship with their attorneys. Corpus Juris Sectum, 1980, Section 4, I bid 99. According to Black Law Dictionary, 5th edition, wards of the court are infants and persons of unsound mind. Are you a person of an unsound mind? Are you considered a ward of the court? Well, you are, if you are the lowercase citizen, 14th Amendment citizen, the civil rights citizen. One of the legal definitions of the word person is an artificial entity. Remember, entity, corporation. Clients are actually not flesh and blood people. We are dead people, dead entities under the all cap name, under the SSTQV Trust. As we go on, you will begin to understand the significance of this. Just stay with me. One thing leads to another. An individual is defined in law as the United States government employee, 5 USC 552A, subsection A, subsection 2, and from Black Law Dictionary 5. It, the words individual, may in proper cases include artificial persons. In other words, not a living man or woman, son or daughter. Artificial persons are persons created and devised by human laws for the purpose of society and government, as distinguished from natural persons. Corporations such as John Doe in all capital letters, Jane Doe in all capital letters, are examples of artificial persons. Black Law Dictionary number 5. The word person comes from the Greek word persona, which means mask. They have placed a governmental entity masking your spiritual physical identity created by God. So they may be able to control all of your assets, your marriage, your sons and daughters, known as children, all aspects of life that you were required to be guaranteed a republic form of government, but this no longer exists when you are considered a person. People are real, but a person is not necessarily real. This word, as used in today's courts, almost always refers to a fiction. The black connection. Another legal definition of person is a human being, Black Law Dictionary 5. Person, an entity such as a corporation, having the rights and duties of a human being, Black Law Dictionary 7. The word person is legal terminology, is perceived as a general word which normally includes in its scope a variety of entities other than human beings. CEG 1 USC subsection 1, Church of Scientology versus U.S. Department of Justice 1979, 612F 2D 417425. Black law doesn't define human beings, but Ballantines Law Dictionary of 1930 does. Let's see what it says. A human being. See monster. Looking up the word monster, we find a human being by birth, but in some part resembling a lower animal. Are you a monster? Are you a human being? A fellow student of law insists that a human is a colored man. But the dictionaries I have consulted so far stay away from this. Random House Webster's Dictionary defines hue as a graduation or variety of color, tint, or two, color. Incidentally, the Supreme Court Chief Justice Roger Janey ruled in the Dred Scott case of 1856 said that Black Americans were neither citizens nor men. If they were so considered, they would be no option but to allow them to own and carry arms without restriction. Dred Scott versus Sanford, 19 Howe, 393, 1856. As you might imagine, this is a very controversial case. I doubt even the gun right groups would dare mention this Supreme Court decision if they knew about it. Anyway, Dred Scott was a slave, and upon his death of his master, it was promised that he would be set free. Instead, he remained detained as a slave. He petitioned the federal court, but lost because he was not a person, as contemplated by the Constitution, and had no right to petition them. This was later overturned by the 13th Amendment, which abolishment of slavery, as well as the 14th Amendment, citizenship. Think of what I'm saying. A lowercase servant aboard a ship. Because again, we're working in commercial aspects of jurisdiction, admiralty, maritime law, citizenship. A study of how the law relates to Black Americans is very revealing. I discovered that I couldn't really avoid this issue and still explain certain key principles of law. Anyway, anyone who draws near this important key is criticized for it, but if you ignore the subject, you will lose more than you may realize. We have to take into consideration through our own spiritual discernment that many cultures of color who have been here in North America have been discriminated throughout the time of history as the colonization of America took place, and also to some form of the present time we live in.